Good evening.
Good evening.
Good evening, everybody. My name is Sai Borotu, and I work as a project officer with the Commonwealth Human Rights Initiative in the Prison Reforms Program. We'll be starting the event shortly. Before that, I would like to make a few quick announcements to rectify and to avoid any technological issues. Thank you for your patience. We'll be starting the meeting shortly. As a general request, to avoid any technical issues, we would request that everybody switch off their videos and audios during the event, apart from the speakers. We will be taking questions from participants from 6:45 to 7 p.m. And we would request that you kindly use the raise hand option below, and the moderator will place the questions before the panel sequentially. This is only to avoid any kind of logistical errors or issues during the course of the event. Thank you so much. Please give me a minute before we start with the event. Hello, good evening to everybody once again. To start with, I would like to request Mr. Sanjay Hazarika, the International Director of Commonwealth Human Rights Initiative, to kindly deliver the welcome address. Sanjay, over to you.
Thank you. I hope I can be heard. I'd like to welcome Justice Madan B Lokur, the former Chief Justice of the Supreme Court, Justice Muralidhar of the Punjab and Haryana High Court, all our esteemed panelists and speakers. They include magistrates from different parts of the country, high officials from prison departments and correctional services in state capitals, from Delhi and districts, and it's really cross-country. In addition, Dr. Fernando Fernandez, who conceptualized and coordinated the report along with the team from CHRI, led by Madhurima Dhanuka, who is the head of the Prison Reforms unit here, and Sai, who is anchoring this session. Dr. Fernandez is a reader at the School of Education and Social Work at the University of Dundee in Scotland. We welcome civil society participants, representatives from state legal service authorities and state human rights commissions. Very briefly, because I don't think you've come to listen to me, many of you will know about CHRI, but very briefly in 3 sentences, the work of CHRI is anchored in access to justice, which all of us are involved in. And that includes prison and police reforms. And this, as I said, this program is being anchored and supported and developed by our prison reforms unit. There is a program we have on access to information, which basically is about RTI, and all our teams, including the RTI team, the Access to Justice team, uses RTI to get information, authentic information from stakeholders, governments, on issues that we work on and are concerned about. There are 2 new programs of work that CHRI does. One is on SDG 8.7, which is on contemporary forms of slavery and human trafficking, and a media program on freedom of expression and media rights. We also have a unit on international advocacy. I believe that the report, which Justice Lokur will be releasing and speaking on, and Justice Muralidharan as well, and other panelists, it's really a unique effort. And CHRI is very first to look at the issue of transgender persons as a vulnerable category in prisons. There are many vulnerable categories, but this is one which I think we all would agree is not adequately documented, recognized, and actively supported in ways to help them get true justice. I believe that this is a logical step for our human rights work and for the LGBTI plus rights community in India to ensure access to justice for disenfranchised communities. And we look forward in the next months and years to working with all of you collaboratively and with fellow stakeholders in this process, that includes governments, mandate holders, and civil society. Again, welcome all of you. I welcome all of you to this program, and I now hand it back to Sai. Thank you.
Thank you so much, Sanjada. Now I would request Dr. Fernando Fernandez, who is a reader at the Department of Education and Social Work in University of Dundee, to speak about the project under which this report is being published. The title of the project is Exploring the Enablers and Barriers for the Protection and Promotion of Human Rights of LGBTI plus persons inside prisons, Dialogues between India and Brazil. Over to you, Professor Fernando. Thank you.
Hello, good morning to everyone. It's a great pleasure to be here with all of you, and so glad to see this happening, the release of this report, which is so important, not only for India, but internationally as well. I just wanted to first thank you, all my colleagues and everyone present here, but especially CHRI, and acknowledge the role of CHRI in taking this agenda forward, and the role of CHRI in taking a human rights agenda forward in India. So it's very pleased in working with CHRI as a partner and looking forward to further collaborative work as part of these reports. Just to say, this research is part of international attempts to look at the situation of transgender people and LGBT people in general, internationally, especially across Brazil and UK and India. We are also producing similar reports in Brazil, and we are just releasing the UK reports in the coming months. And the idea for this project initially was to identify the key issues and drivers for human rights in prisons for this specific group of people. As Sanjoy very said, it's one of the most vulnerable peoples in prison. There are any others as well, but we wanted to pay special attention to these specific groups in this project. We understand that law and the policies across countries vary a lot, and it has to do also with the state of cultural affairs and also political issues in every country. But we understand also that we have interesting and very strong international frameworks in support to secure human rights in prisons in this country. So the idea for this report is first create this opportunity for dialogue and bring people together around a subject that certainly is not very studied and investigated, especially in India, as we came to know, but also trying to create the opportunity to advance in policy and practice, and of course in support to advocacy groups as well, in pushing government agendas towards more protective frameworks for transgender people in prisons. So I really wanted to thank you again for this opportunity to be together. Just to say that the findings for this project are going to be taken forward, and you are really looking in terms of further collaborative work. And that's my words. I don't want to be very long, and pass the words to Sai. Thank you so much again.
Thank you, Professor Fernando, for the same. Right now, we will be waiting for the launch of the report. Kindly give me a minute before I can play the video. Thank you for your patience.
In these online times, we thought of a small gesture of, just how to kind of launch the report. So a small video was prepared by Sai just as a symbolic gesture.
That was the launch of the report. So I would firstly like to congratulate Sanjay and the authors of the report for the report having been launched. This is surely a very important piece of literature to taking transgender rights forward in India and also to start conversations on transgender persons in prisons in India. Now we will go on to the presentation of the key reports and findings. For that, I would like to invite Madhurima Dhanika, who is the program head for Prison Reforms Program at Commonwealth Human Rights Initiative, to kindly put across a few points, and then I will start with the presentation of the findings and recommendations. Over to you, Madhurima.
Yeah, thank you, Sai, for this, and thank you everyone for being part of this event here. I'm very happy that we have been able to have so many participants, and we have a number of them have joined on this platform, and we have a large number of people listening in on the YouTube live stream that we are doing. And something that I feel is good about the virtual world that we live in now is that the outreach can probably be a little bit more when we use these platforms. So having said that, on the report, so Sai will be coming in and sharing the details about the report and the findings and, the recommendations, what we have come out with, what needs assistance. But what I want to focus on is the fact that, this report is a first step. It's a very valuable first step in the direction of protecting the rights of transgender persons who are confined in prisons in India. And what we need to remember, and what I want everyone to, this is our future, like the way we want to take it forward is to be able to use what we have come out. Now, what we are there is not the answers. We haven't provided answers. We've thrown up the questions which need answers, and the answers need to be developed, need to be worked upon in a collaborative manner by governments, by authorities, by governments, by civil society. The more there will be, that will actually help in terms of promoting and taking forward the various recommendations that we have brought out and to actually secure the rights of transgender persons in prisons in India. At that note, I am going to stop and I hand it over to you, Sai, to share the findings and the recommendations. Thank you.
Thank you so much, Madhurima, for summing it up so beautifully. It is true that this report would be a conversation starter to address a vulnerable community that has not been addressed historically. And specifically in the context of prisons, this would be one of its kind, the way in which this report has come out. Kindly give me a second before I start the presentations and speak about the report.
Both are the same thing. No, sir. That's the reasoning. Open this. Both these guys are.
Sai, you're on mute. We haven't been able to hear you at all. So you'll have to go back to the beginning because you're muted. Thank you. Can you go back to the start?
Yes. Sorry for that technical error. I was introducing myself for the benefit of those who have not been able to join us in the beginning. My name is Sai Borotu. I work as a project officer at the Prison Reforms Program at Commonwealth Human Rights Initiative. I have also been associated with the project that is responsible for delivering this report at present. I'll take you forward to the findings and the recommendations of the report through the help of a PowerPoint presentation. I'm hoping that the PowerPoint presentation is visible to everybody who is participating. If not, kindly do message on the chat box so that any technical glitches on that end can be covered. Going forward, I was mentioning that the title of the report is Lost Identity, Transgender Persons in Indian Prisons, and that is also reflective of the kind of identity issues that are faced by transgender people in Indian prisons. That starts with a lack of recognition of transgender persons as an identity and a lack of procedure and protocol to take that forward as well. The report largely focuses on the international legal frameworks and the national legal frameworks that are in place for the protection of policies, frameworks and protocols that are in place for the admission, search and segregation of transgender individuals in Indian prisons. The report was finalized through a consultative process, and the consultative process included two major segments. The first segment was an e-consultation and an open call for comments, which was sent out to community members of the transgender community, that was sent out to civil society organizations, community-based organizations, academicians, activists, individuals, and collectives working around the issues of transgender persons. The second segment that was taken forward in the consultative processes was the virtual consultation, where there were in-depth discussions on the recommendations of the report, and there were community-based organizations, individuals of the transgender community, and collectives that participated in this. The report is meant to largely reach state and non-state actors. In state actors, we are hoping to reach out to judicial officers, prison authorities, state legal authorities, and central legal authorities, and governments at both the central and state level. Similarly, we're also trying to reach out to autonomous organizations and bodies which have a role in the monitoring of prisons in India. Apart from all of this, the context of the report also allows for this report to be a central piece of literature in trying to understand experiences of transgender persons for academicians who are trying to work in the issues of either criminology, sociology, law, or social work. I would like to take some time to focus on the limitations of the report. The limitations of the report start with the definition of transgender. The time frame which was chosen to collect the data was also a time frame which saw extensive policy being made on transgender persons in India. This period of time saw the Transgender Persons Protection of Rights Bill being placed in Parliament, and this period also saw multiple protests and recommendations against the bill that were sought by the transgender community. In this milieu, the definition of a transgender person was largely restricted to, or is otherwise generally perceived to be, male gender assigned at birth individuals, and more specifically, socio-religious communities that include Hijra, Aravani, Jogata, Jogappa communities, while at the same time not taking into account necessarily people who are pre-operative transgender persons, not necessarily taking into account transgender persons who are not vocal about their identity, and hence the limitation follows about the various transgender people that exist and the transgender people that might have been left behind because of various confusions in definitions, etc. Going forward, another limitation of the report is obviously that in trying to understand vulnerability through gender and sexual orientation in the context of prisons, we have not been able to gather data or frame perspectives around lesbian, gay, bisexual, or MSM persons who are placed inside prisons. This is something that we are hoping to do in future reports, but as an initiation into the concept of looking at gendered and sexual orientation based vulnerabilities inside prisons, this would be an initial step. Thirdly, the limitation that I would like to also mention here is the lack of responses from all jails when the RTI was transferred to individual jails from prison headquarters. The process of RTI filing usually was started with a RTI being filed to the prison headquarters in many cases where the prison headquarters forwarded the same to its various jails for a response on the data of transgender persons that we had sought. Given these three limitations, I would like to go forward to the findings of the report now. One of the major findings of the report is the number of transgender persons in Indian prisons. 214 transgender persons were in Indian prisons during the time frame of May 2018 to April 2019. This is integral to also understand that a population that was not legally recognized for a very long time, that a population that does not have policy frameworks to depend on for a equal and equitable access to justice. 214 of these people were present in Indian prisons during this 1 year period. The second finding that comes across is the recording of data for transgender persons. As we are aware, Indian prisons are gendered institutions which have male and female prisons. Mostly they are male prisons where there are wards specifically designated for women prisoners. However, in the data that we had sought, we requested prison departments to inform us whether data for transgender persons was recorded beyond the gender binary of male and female. Only 9 of the states out of 28 states and 6 union territories that responded told us that they maintain separate data for transgender persons in prisons. The second finding that we would be talking about today is the usage of insensitive terminology. Many of the prison departments that mentioned the availability of data for transgender persons also mentioned that the e-prison software is the location where this data is maintained. However, they are not maintained under the category of the person being a transgender person, but instead under the category of eunuch. The word eunuch has historically been a derogatory word used to refer to transgender persons. The reason why it is derogatory is that a eunuch literally means a castrated male, which does not have anything to do with the person's gender identity, and hence referring to a transgender person as eunuch is insensitive and offensive. The process of segregation is something that we have been able to focus on during the RTI questioning as well. There have been largely 6 ways in which transgender persons who are at present in Indian prisons have been segregated. The first of these is that they were placed in the male-female wards based on their genitalia. The actual reason that was suggested here was not mentioned. However, it was informed that the segregation was happening primarily on the basis of genitalia, that is sex assigned at birth as identified by the medical officer. Further, male-female transgender persons were kept separately is a second category of responses that we received from prisons. In this, it was stated that after admission to prisons, transgender persons were kept separately from male and female inmates. However, some of the states further state that the segregation was maintained by either confining transgender persons in separate cells, isolation wards, or inside hospitals. There were no separate provisions for transgender persons to be placed because there were no previous cases of transgender persons being placed in prisons. Further, they mentioned that jail manuals only contain provisions regarding the segregation and placement of male and female prisoners, and hence there were no provisions to support transgender prisoners inside a prison. Going forward to the next finding of the report, we asked the prison departments regarding training and recruitment of transgender individuals and also training conducted for prison officials to deal with transgender persons and to make sure that there was a humane approach to understanding, recognizing, and protecting the rights of transgender persons in prisons. There were no training programs that were conducted since 2014, apart from the state of Karnataka. No transgender persons were hired between 1st January 2014 and 1st January 2019 across the country in any of the prison departments. So these are major findings that have been taken up. We will now move forward to the major recommendations of the report. As an overarching principle, we have suggested and we will advocate for that all policy measures that will be devised for transgender persons in relation to prisons, in relation to access to justice, must be done through extensive community collaborations, community consultations, and another major recommendation that we have, and as a major overarching principle to the recommendations that we have, is that the directives of the Supreme Court of India in Nalsa versus Union of India, specifically regarding two rights of self-determined gender identity and non-discrimination, must be strongly implemented in recruitment, admission, search, and policy devised for the same. Going forward, the policy initiatives and the recommendations that we would recommend there are that the central government may formulate a policy for the Model Prison Manual. The Model Prison Manual is a document that has been prepared by the central government, that have been devised by the central government for various different policies concerning prisons. The central government may also direct the National Crime Records Bureau to record data on transgender persons. And this is basically to address the lacunae in data regarding transgender persons in prisons that has been noticed through the report. Another major factor of what we would be recommending is protecting rights of transgender persons inside prisons. The state governments must make sure to a certain extent that any transgender person, if they wish to, should be allowed to make or should be facilitated to make instead a transgender certificate as per Section 5 of the Transgender Persons Protection of Rights Act. I would like to further state over here that given the legal challenges to the Transgender Persons Protection of Rights Act, we would request that the most sensitive way that could be devised to understand the legal challenge and to respect the principles laid down in NALSA of self-determination of gender identity must be taken into consideration while talking about either admission, search, or segregation of transgender persons. Having reasserted that, the next suggestion that we have is that a complaints officer must be designated as per the Transgender Persons Act in all prisons across the country. Apart from recommendations that relate to the recruitment, training, and placement and segregation of transgender persons, India has a long tradition of making sure that there is a judicial overview of prisons. In this context, we have recommended that the state government should designate members of the Transgender Welfare Board, which were established under the Nalsa versus Union of India judgment as part of the Board of Visitors. All procedures provided in the state prison rules must be administered to transgender persons based on their self-identity. For example, a few examples that we have stated here on the same are medical examinations and reference to outside hospitals, requisition of police escorts, etc. The basic recommendation that would go behind this is that wherever there are gendered specific rules and wherever these gendered specific rules are meant for the protection of people who are vulnerable to either violence or violation of rights must also include transgender persons as a vulnerable category and take cognizance of the vulnerability of transgender persons in prisons. Awareness programs is the next recommendation that we would like to suggest here. Prison departments and National Legal Service Authorities, State Legal Service Authorities, and other stakeholders may devise awareness and sensitization programs for jail visiting lawyers, paralegal volunteers, and prisoners on the issues of transgender persons. The measures may include, but not limited to, making available resources from information communication and education material on the same, including pamphlets, posters, videos, or whatever is the medium that reaches out to the most people present. The next recommendation that we have is regarding the training of stakeholders. The central government may direct BPRE to revise, update Unit 6, which contains the transgender persons, to include recent developments. State governments, prison departments should ensure that training curriculums for prison officers and warders must include specialized courses on gender identity and sexual orientation. Another call that we would like to give to all civil society organizations, autonomous institutions such as the National Human Rights Commission and the state commissions for the protection of rights of women, children, as well as state legal service authorities and individual activists, academic institutions, etc., that the documentation of experiences for transgender people in Indian prisons is integral to creating a consultative and responsive policy for the inclusion of transgender people and also for the protection of transgender people's rights. Similarly, we also would like to call for more research and documenting of experiences regarding infrastructural issues which are faced by transgender persons, apart from medical histories and vulnerabilities that trans people face, including HIV and other sexually transmitted infections and diseases, and the treatment for the same inside prisons. There also further needs to be documentation on the kind of experiences transgender people have while interacting with various facets of the criminal justice system, including police, prisons, and courts. There also needs to be documentation of the need for and the access to legal assistance or legal aid, and the ways in which not being able to depend on natal or biological families, which is a specific context that transgender people bring, to respond to that issue, we would request for more documentation of experiences of transgender persons who come in conflict with law. Thank you so much, everyone, for your patience. I would like to now invite Justice Madan B Lokur, who is a retired judge from the Supreme Court of India and part of the Executive Committee of CHRI, to kindly deliver the keynote speech.
Yeah, thank you, Sai. That was a wonderful presentation, and I must congratulate you and Madhurima for an excellent report. Like Madhurima said, it's the first step, towards fulfillment of some of the rights of transgender persons, but it's an important step. I've gone through your report, and it's what I find was that you had challenges to face much more than one would expect in getting information about a variety of things. Very often, the jail staff did not respond to your requests. RTI was perhaps responded to in some cases, but not in many cases. So that by itself, was a challenge, collection of data, the analysis, and so on and so forth. But I'm glad that you've been able to overcome all these challenges and come out with this excellent report. There are a few thoughts that I would like to share on this. One is with regard to the problems that transgender persons face, not only in prisons, but even outside the prisons. And I would assume that these get more acute or perhaps more magnified in prisons. And these pertain to harassment of a variety of kinds, abuse, physical abuse. It could, in some cases, amount to even beating up persons and so on. A disregard to their gender identity, issues of medical negligence. Not medical negligence, but medical facilities, whether they are available or they're not available. You may have a doctor who is not trained in dealing with some of the issues that are placed before them by transgender persons. So there are a variety of these kind of issues And I think that is something that we should all be mindful of. We are dealing with a group that is vulnerable. And unfortunately, as it appears from the report, the transgender persons are more or less treated as outcasts. So you have a separate ward for them. Facilities which should be available to them are not, made available to them. So, if you put the whole, the issues of harassment, abuse, so on and so forth, the fact that they are vulnerable, sections of society, what you really require is training. I think that is very, very important. Unfortunately, we have not spent any time on training of personnel in dealing with issues which are arising on a day-to-day basis in our society. You will recall that recently, maybe about a week or 2 weeks back, the Attorney General for India said that judges need to be sensitized on gender issues. So really, for some reason, we're not looking at some of these issues which are facing society and on which we must concentrate. So you have, gender sensitization. Now, after the judgment of NALSA, and there is a recognition of the third gender, it's not that, things have suddenly changed, that transgender persons were treated differently before the judgment and they're treated differently after the judgment. That's not what has happened. But what has happened is the recognition that has been given to them by law that they are a third gender. But that does not necessarily percolate to an awareness in society. I mean, how many people would be aware that the Supreme Court has taken a decision and has said that transgender persons are a part of the third gender? How many people would really be concerned about it? How many people would go out of their way to recognize the rights of transgender persons? So it is in this context, that that training, awareness is very, very important. And all institutions, whether it is institutions dealing with the police, the National Police Academy or the Bureau of Police Research and Development, whether it's the Judiciary, judicial academies, whether it's institutions dealing with civil servants, the academy at Mussoorie, for example, and state academies, they all need to get together and look at these issues, particularly with regard to transgender persons. Now, sometimes, I've had this experience that the bureaucracy says, well, it's nice for you to talk about these kind of things, but then what are we supposed to do? I'll give you an example. There are many places where, children in conflict with law, in a district there would be only one child. Now, the law requires that there should be an observation home in every district. I have been told many times that, there are only 1 or 2 children over there, maybe 3 or 4 children. Are we going to construct, a home for them, an observation home for them? Are we going to recruit people? We'll end up spending much more money in, housing these children, looking after them, and so on. Now, I don't think that's an answer. That's not an answer to the question, because it is the duty of the state. Ours is a welfare state. We have to realize that. And a welfare state cannot say that, listen, I don't have money. A welfare state cannot say, well, I don't have certain facilities, or I would not like to give certain facilities to some people, but I don't mind giving them to other people. That's not what a welfare state is supposed to do. So some of these issues, I'm sure we will encounter in due course of time, that, well, it's nice for you to talk about, looking after transgender persons in prisons. But what can we do? There's only one transgender person, or there are only 5 transgender persons. What are we supposed to do out of, maybe a couple of thousand transgender persons? I don't think that's an answer. And the answers to these questions can only come through adequate training and understanding the problems that they face. So really, it's a very, very important issue that you have raised about awareness and recruitment and training and so on. The second thing that I would like to mention is about availability of legal aid. Now, your report obviously cannot and does not mention about how many of these transgender persons are in prison because they have not been given proper legal assistance. It is a matter of common knowledge that very often legal aid is not provided to the person who is brought before a magistrate, and if the legal aid that is provided is kind of cursory legal aid, just for the paper. You will recall very recently the case of one super senior citizen, 83-year-old person who has been arrested. All that he wanted was, he suffers from Parkinson's disease. All that he wanted was a straw and a sipper, because his hands, his hand movement is such that he's unable to hold a glass of water. All that he wanted was a straw and a sipper so that he could drink water. And what does the investigating agency say? They say that we need 20 days time to file a reply to this request. What does the judiciary do? The judiciary says, all right, we'll give you 20 days time to file a reply. Now that is insensitivity. Now, a situation like this, of course, the minister in the state cabinet said, all right, you give him the straw, give him the sipper. But does something like this have to actually go to the minister of a cabinet, for a straw or for a sipper? These are issues where legal aid lawyers can make a difference, where they can say that, well, and I would request all the, member secretaries of the various district legal services authorities and state legal services authorities who are present here today, that you have to sensitize your lawyers as well. Now this is something which could have been taken care of in the case of the super senior citizen. It could have been taken care of on day one, rather than 20 days for a national, investigating agency to file a reply and, investigate about this. So it's not only, some sections of society, but also some certain specialized sections of society who come into contact or who may come into contact with transgender persons who need to be sensitized. And I'm referring in this case to lawyers who, are assisting the legal aid authorities. Now, what actually happens in a prison is very difficult to find out. My first interaction in a prison was way back in 1995, if I remember correctly, when officially we had a commission, the Justice Leela Seth Commission, that was looking into the circumstances which led to the death of one Mr. Rajan Pillai. And one of the terms of reference was, the conditions in Tihar jail. I accompanied Justice Leela Seth. I was the counsel for the commission at that time. We went to Tihar jail. We had a look, but you can't, it's impossible. You can't look at every nook and corner to find out what exactly is happening. There are requirements that there should be a complaint box in the prison. How often are those complaint boxes actually, how many of them have actually been put up? How many of them are actually being used by the prisoners? How many of these complaints are actually being redressed? There is just no way to find out all this. So really, it's while these ideas are very good, you have given some extremely good recommendations. The problem is one of implementation. That's where it is lacking, and it's really difficult to find out, the degree of implementation, the manner of implementation, the compliance of directions, and so on. When I was in the Supreme Court, one of the things that we had directed was, at that point of time, a model prison manual was being prepared. And it was being prepared and being prepared and being prepared. So we gave a direction that, listen, how about completing it? It just can't go on forever that you prepare a model prison manual. A model prison manual was eventually prepared. It was circulated. Now, things change over a period of time. 5 years ago, 10 years ago, transgender persons were not recognized. Today they are. We directed that the model prison manual should be reviewed after a period of 1 year, so that from the learning, improvements can be made, changes can be made. There could be some areas which have not been thought of and which need to be thought of. So these changes were expected, and we required the model prison manual to be, updated and changed if necessary, but certainly reviewed after a period of 1 year. I'm afraid that has not been done. Now, again, it's a question of implementation. We appointed a former judge of the Supreme Court, Justice Amitav Roy, as a committee to look into certain aspects of prison management. Now, I believe he has given some kind of a preliminary report. I'm not very sure about it. But, the final report has not yet come. So when we are dealing with, transgender persons in prisons, we have a whole lot of challenges that are faced and that we are going to face from time to time. And the problem and the issue really is of ensuring that whatever is done, whatever recommendations you have made, are faithfully implemented, sincerely implemented by a staff that is dedicated, that is by a staff that is aware of the problem, and a staff that is adequately trained and sensitized in the issues. The responsibilities of the justice delivery system, I have mentioned, to look at the issues, with compassion. It's not that, just because a person is a transgender person, therefore you look at the issue with compassion. No, you look at the issue with compassion in respect of everybody, whether that person is a super senior citizen or not a super senior citizen, whether that person is a transgender person or not a transgender person. And that is where training of judges comes in, and the lawyer who is representing any person, sensitization of that lawyer, training of that lawyer, and I would request the legal aid authorities present today to look into this. It is like Madhurima said, that this is a first step in a larger struggle for prison reforms. There are a whole range of reforms that are required in prisons. The Supreme Court has been talking about it, since 1978, 79, 80, from the Sunil Batra case onwards, Charles Sobraj case. There's so many of them. Now, from 1980 till 2020, we're talking about 40 years. But reforms are still the subject matter of discussion, and the kind of reforms that are expected, the kind of reforms that have been suggested have not yet come about. So really, it's a uphill kind of a struggle that we are going to face. But I'm glad you've taken up this issue, and the fact that you've been able to come out with this report is an indication that you are able to overcome the challenges that were put before you. For whatever reason, I don't want to go behind the reasons. The way forward is what you have recommended. We have to ensure that transgender persons every person, including transgender persons, are able to realize their rights. It's not that their rights are cast in stone only by the judgment of the Supreme Court. They have other rights as well. And we have to recognize them, and we have to make sure that society recognizes them, and a microcosm of society, which is prisons, also recognizes them. So thank you very much for giving me this opportunity to share some thoughts, and congratulations really for a magnificent job that you have done. Thank you very much.
Thank you so much, Justice Lokur, for those kind words. I would also like to take a moment to acknowledge the lead author of the report, who is Arijit Ghosh, a former employee of Commonwealth Human Rights Initiative in the Prison Reforms Program, who's currently working as a lecturer in OP Jindal Global University. Having said that, right now we would request all the panelists who would be speaking in the next panel to switch on their videos so that we will be able to go in that sequence. I would like to introduce, to start with, all the panelists who will be joining us today. The title of the panel that we'll be speaking about is Protecting the Rights of Transgender Persons in Indian Prisons. I would request that I be given a few seconds to make sure that all technical errors are corrected. Kindly bear with me. Thank you for your patience. Thank you everyone for your patience. As I already mentioned, the title of the panel that we are about to present now is Protecting the Rights of Transgender Persons in Indian Prisons. It is my honor to introduce our esteemed panel. I would like to introduce the panel one by one in sequence of their views. First, we have Karthik Bittu Kondaya, who's a professor at the Ashoka University. We have Rachna Mudramoina, who is an acting director at the Human Rights Law Network. We have Amritananda Chakravarti, who's an advocate and who has worked on the issues of violence against trans persons. We have Jaina Kothari, who's a senior advocate and the executive director for Center for Law and Policy Research. We have Dr. Ahmed, who is a former director of Academy for Police and Correctional Training. Then we have Justice S. Murlidhar, who is a judge at the Punjab and Haryana High Court. I would like to take this opportunity to welcome each and every one of our panelists. And I would like to hand over now to Karthik Bittu Kondaya to put across their points.
Thank you very much, Sai, and thank you for authoring this report. It is an honor to be on the panel with and be addressing.
Bittu, if I may interject for a moment, we could not hear you properly. Could you make sure that the mic is placed closer to you?
How is this? I'll just speak a little bit louder. Are you able to hear me?
Yes.
Okay, wonderful.
Yeah, maybe speaking a little bit louder would actually help. Yeah, sure. Thanks.
Thank you.
All right. I just wanted to say thank you to all of you for writing this report, for organizing this, and thank you also to the many people from the legal establishment, the prison establishment, and the administration who have taken time to listen to us. I know that all of your time is very valuable. My name is Bittu. I am a trans man, and the reason it's important for me to say this is because the standard understanding of who a transgender person is typically a transgender woman. I am a non-binary trans man, and
राजेश रंजन नहीं है और क्या फिर ये लोग नीचे अमिताभ कांत लिख के दिया कोई बात नहीं
So I'm a trans man, which means that I was assigned a female gender at birth, and I do not identify with that gender. As such, I'm also a professor of biology, and I'm also somebody who has been a prisoner. And so I speak from all three of these perspectives on this question. Okay, so the first thing that I would say is that for jails to effectively come up with an understanding of how trans persons are to be treated in prisons, this has to take on board the reality that trans persons may include transgender women, may include transgender men, and may include non-binary identified people. And so, for example, I teach in an educational residential institution, and we have to take all of these same categories on board when we administer students here, when we consider their residences. And so we ensure everybody has access to gender-neutral bathrooms, that residences are chosen by the transgender student. So for example, many transgender men like myself, both when it comes to hostel residences in a university and when it comes to a jail, there may be individual to individual variation in whether we would want to be housed in a separate wing of a women's prison or in a men's prison. And so I think the key thing that I would like to stress as the first point is that trans people are not a single homogeneous category. Although the word third gender has been claimed by some transgender persons, it certainly does not apply to some other transgender persons. And so it's not an umbrella category for us, and we're not all the same kind of person, either in terms of our physical requirements or in terms of what it is that we would need in terms of gendered accommodation in the prison system. The second and important thing that I want to point out, as I said, I've been a prisoner myself, and I was arrested in the context of a non-violent dharna that we were carrying out. And as you know, many people, including many of the founding members of this country, have been to through extended periods of being jailed. And so it's important to remember that the process of jailing itself should not, the act of us being, in some sense, held away from society is punishment enough. And it is important that that punishment not be amplified, especially for transgender persons. Several people get jailed in the pursuit of justice, and several transgender persons get jailed just by virtue of being transgender. So this is important to remember, because we live in a particular system of really a sort of Brahminical patriarchy, which allots jobs to everybody, right? Jobs are assigned, and transgender persons, once perceived as transgender, are not given access to the same jobs as most people, right? Transgender people are largely relegated into professions which were historically stigmatized. For transgender women, this has largely been begging and sex work, and dancing sometimes. But for transgender men as well, because there's no formal employment, most people have to work as roadside vendors, the chotu in the tea shop. These are the kinds of jobs which a lot of working class trans men take, taxis and auto driving, and all of these professions, you come in conflict with the law, and that is just structurally built into how the law is set up. So in some sense, the law kind of, and of course, in some cases, as with what was the Hyderabad Eunuchs Act, which has now been legally challenged, the British themselves took forward this notion and classified transgender persons as a criminal tribe. And a presupposition of criminality often colors the way in which the criminal justice system engages with transgender persons. So a lot of trans persons have gone to jail for cases such as 420, right? Cases such as being considered frauds just because our IDs may not match our appearance. And so it's important to remember that several trans people, and certainly when I went to jail as well, there were trans persons there who were there on account of some of these cases. The third thing I want to say is that the standard procedure, at least when I entered jail on remand, was that people get stripped upon their entry to jail, right? You are typically asked to strip and a bodily check is done. In my case, this was done for me and another trans person together, and we were arrested with a group of largely women. So we were all sent to a women's jail, and we were all asked to disrobe in the jail. And that process was particularly humiliating and difficult for transgender individuals. You have to understand that what makes us transgender is not necessarily our bodies. People who are intersex and trans may have bodies that vary from male and female, but most non-intersex transgender persons, the main thing is that our brain's expectation of the sensory input from our body doesn't match what the body's physical sensory input is like. And so any attention that we pay to our own bodies is very difficult for us to handle. That's what causes gender dysphoria. That's what causes many of us to undergo various interventions to change our bodies, since brains are not, as it turns out, changeable on this account. And so, the process of stripping is, and in general, even around very trusted persons, partners, anybody even very close to us, is extremely difficult for us. And the process of stripping as an entry into the jail, I'm sure I remember it was difficult for many of the cis women with us also. And I feel that procedure needs to be amended also for the jail system to be more sensitive. And then the third thing I want to point out is what Sai had already alluded to, which is that essentially, when one's going to jail, knows that if one declares oneself as trans, one is effectively going to be in some form of near solitary confinement. And we know how difficult solitary confinement can be. Balancing that with the necessity for trans persons to essentially have access to social interaction, because especially with COVID, the amount of research on the ways in which social interaction and solitary confinement in general can affect people is very, very, we know how intensely strong it is. And even in the experiments that we do with animal behavior in our lab, we can see how much animals will do so much more for social interaction than they will for food alone. So in general, I find solitary confinement to be a problematic practice in prisons. And I think that for trans persons, it is particularly so. I'm also one of the trans persons for whom jail is a critical reason as to why I have not transitioned on paper, right? And this is because I worry about what will happen to me once I am listed as transgender on paper, largely when it comes to interactions with the criminal justice system. I think that very few trans persons understand this, because it's also very specific to the experience of being trans and having been jailed in the past. So this is the third thing that I would say, and I would like to suggest reforms along those lines, as well as a sort of healthy, healthy discussion, which is led by inputs from the transgender community on how accommodations for transgender persons in prisons must be made. Plus, there needs to be a rethinking of the idea of putting people in jail in the context of their grappling with unfair socioeconomic conditions, which continue to deprive transgender persons of employment opportunities. And I think that in many offenses of the kind that trans people are routinely arrested for begging, arrested while doing sex work, that incarceration should, in fact, this is something for the law to take up more generally, that incarceration is not a solution, and that the criminal justice system should think more about what restorative justice and about providing and ensuring opportunities for trans persons to flourish, what that would look like instead. Thank you very much.
Thank you so much, Bittu, for your thoughts. That was really an experience that needed to be put out there, and that a number of people who are also participants here could learn from. Going forward, the next person on the panel is Ms. Rachna Mudraboina, who's an executive director at the Human Rights Law Network.
Hello, am I audible?
Yes, you are, Rachna. Over to you.
Thank you. Thank you. Thank you for considering me as a speaker, and thank you for all the people who are participated in this research, and also congratulations for hailing this report on transgender people. I thank each and everyone for that and for this research. First of all, I would like to introduce myself. I'm a Rachna. I'm from Hyderabad, Telangana region. I'm a trans woman, identify myself, and by profession, I'm a sex worker. So while come to the trans people, you all know that most of the trans women or mostly you see the hijra women are mostly into the begging, either begging or sex work as their profession universally, because of the various reasons as previously been told that we are denial of all the facilities for the traditional employment and education system into. So that hierarchies existed over there, that hierarchies of class, caste, everything exists over there. And when coming to the sex work, it's because sex work is being a taboo in our Indian society. Sex work per se itself is not criminalized, but the locality or the environment around the sex work has been criminalized a lot, you as you all know, and the soliciting in the public places and lot of such and the income of sex workers have been criminalized through various laws like ITPA, and also often trans women who are into the sex work have been booked under the PT cases. So it has been institutionalized from a long period that trans women have been supplied as the commodities for the PT cases into the criminal law system. Uh, on the same row, I have been also put into the prison once upon a time in 2005, when once like I have been just arrested for being in a place of sex work, and because that's my chosen profession, being also have been educated, have been denied for a lot of employment opportunities. So what I want to explain is once a transgender sex worker have been into the prison, and there have been a lot of criminalization takes over behind that person after so and so has been into the prison as a victim. So one need to so the first discrimination starts from as we too said that like how trans men are stripped off, the same way trans women are also stripped off just to know about their gender. If trans so there is a lot of confusion and conflation of the genetic organs, genitalia, and also the self-identified gender, which the Nalsa versus Union of India Supreme Court judgment has been saying. So the Supreme Court has been very clearly said that gender is not pertaining to body. It's a continuum between two genders of male and female, and it can be put in between in any particular gender. So the Supreme Court decision gives the transgender people a self-identity system of telling their own gender, whether trans or not, and also to be identified oneself as a trans male or female. So this so-called stripping of trans people's body to assign the gender is the first thing which has to be get rid of when we enter into the prisons. That is the first reason. Being a trans person, I would like all of you to be considering, because we have, including me, we have a large number of experiences who have been into the prisons, because being into sex work, being into begging, a lot of the transgender women or the hijra women have been regularly and frequently visiting the prisons, because there is a sort of institutionalization of criminalization of such community who are living on the roads for their livelihood. So apart from stripping their bodies, they also take the measurements of the organs, which is very inhuman. You know, they take the weight of the genitalia, which is also again inhuman, and no such assessment happens with if it at all it happens with the cis gender assigned people also, it should be treated as inhuman. So this is the first point I want to hail. The second thing is that the trans women who are particularly into the sex work, being the sex work itself has been criminalized a lot, and the environment behind around it has been criminalized a lot. The persons or the working place where mostly trans sex workers work in have been criminalized a lot, and once the person have been into the prison, so and so person will be noted under. Now there is a legal challenge has been thrown on Hyderabad Unix Act now. As you all know, there is a Prevention Tribes Act, which hails its roots from the British era, where post-British era, where the trans people have been curtailed to be enter into the so-called province, and have been asked for their identity, to prove their identity, for being to enter into a city or leave the city. So such ideologies, such notions should not be reasserted on the people, mostly on the people who are into the sex, trans women who are into the sex work, because such curtailing or such denying of movement of freedom of people is not only inhuman but also against the freedom, rights of freedom which our constitution has been given us. Like, so these are the 2 points which I want to throw more light. One is non-stripping of the persons and non-testing of genitalia, because though the NALSA judgment, NALSA was Union of India 2014 judgment, Supreme Court has cleared that, and though 2019 Act of Transgender Persons Protection of Rights Act again goes on the face of this judgment, saying that the women and male identity can be only given after the surgeon certificates. This has been still pending in the Supreme Court. So we need to sensitize our prisoners, prison authorities, and also the police authorities not to strip the bodies of trans people. Second thing is not to criminalize the environment or the routine work of the trans people who are into the sex work. Thank you.
Thank you so much, Rachna, to bring into context not just historical criminalization from the Criminal Tribes Act, but to also resound how remnants of the Criminal Tribes Act in the form of the Hyderabad Eunuchs Act were in force as recently as 2016 in Hyderabad. Further, also to highlight the vulnerability of trans sex workers due to lack of opportunities and due to a systemic brahminical patriarchy which forces trans bodies to engage in such labor. We'll go forward to our next speaker now, Amritananda Chakravarti. I would request that Amritananda Chakravarti please switch on their video.
Thank you, Sai. Hi, am I audible?
Yes, you are. Over to you, Amrita.
Thank you, CHRI, and especially Sai and Madhurima for organizing this fantastic panel on this very, very critical issue, and for facilitating the publication of this report. I mean, as Sai had said, this is a conversation starter, and I am so glad that this has finally happened, and we are talking about criminalization of transgender persons and incarceration, and in the violation of rights in prison settings. And I'm so glad that Bittu and Rachna have already laid the foundation of the discussion and what are the ground realities that we are talking about. I mean, it is as basic as being stripped at the entry of a prison setting, of a trans person, being the genitalia being under complete scrutiny, being dehumanized. So this is the context in which we are talking about transgender persons, their dignity, their autonomy, and their rights. And as Bittu and Rachna have said very clearly, that it's a classic dilemma of how criminal law has been the center of the lives and experiences of transgender persons for like almost more than a century. Right from the Criminal Tribes Act of 1872, and even if we go back to Section 377 of 1860 fame, yet there is complete invisibility and erasure of of transgender persons from the ambit of protection and the procedural safeguards of criminal law. So this is the classic framework with which we are talking about, and whether it is, the colonial laws of 377 or Criminal Tribes Act, or it is, as Bittu said or Rachna said, the anti-begging laws, the Immoral Traffic Prevention Act, the Hyderabad Eunuch Act, the Karnataka Police Act amendment that had happened just few years back. All of these are saying what? This is like a message from the legal system that you can actually criminalize an entire community just by their identity. I mean, it is not about actions or acts. It is about identity that is being criminalized. And that is what I'm so glad I'm on this panel with Justice Muralidhar, who in Nhrc Foundation judgment had famously said that House 377 kind of denudes the moral citizenship of transgender persons. That is what we are talking about. You are striking at the root of dignity and autonomy of persons for who they are. I mean, we are not talking about whether they are committing an offense. Just their existence is a crime in the Indian Penal Code. So, and then we have the Nhrc judgment, and then we have the landmark judgment of Supreme Court in National Legal Services Authority, and then we have the decriminalization, and then again decriminalization in Naftage. So, but as again, Justice Lokur very clearly said that on ground, so we have had these very, very fantastic judgments of Nalsa and Naftage. But on the ground, as Rachna and Bittu have very elaborated, that things don't change and haven't changed. And that is the crux of the issue, that why have they not changed? And being a lawyer working with the queer community for the last 10 years and currently dealing with lots of cases of queer couples, including transgender persons, where not directly I have worked in the prison context, but basically the interaction between the police and the criminal justice system with the trans community and the transgender persons. And you see, when we are talking about daily existence being criminalized, it is the basic, when we are going. So the first thing is, as people have said, transgender persons, there's a complete distrust of the criminal law and the legal system, because the legal system has for so long till date is only criminalizing you, has not come to our aid. So if this is the context, it's very difficult. If as a lawyer, I'll tell the client comes to me and I'll say, okay, you are facing harassment from your family, you're facing harassment on the streets, let's go to the police and let's file a complaint. It takes hours and hours of counseling to tell the client that no, we will go with you, let's go to the police station. On not all experiences would be so bad. But most experiences are bad, even with a lawyer accompanying the transgender person. So, it starts right, as Bittu said, it starts right at how you are being addressed, what name. So, and there are so many trans persons, even after NALSA, who have not managed to change their documents. Because again, it's the same thing. The systems, the facilities, the infrastructure that is required to facilitate the realization of fundamental rights, they have not been put in place. And so NALSA is 2014, we are in 2020, 6 years, and we still have not seen, and as Justice Lokur said, implementation, NALSA has not been, it is the community that has taken NALSA to heart and is protesting at every point. But if you're talking about the government, if you're talking about authorities, they have not embraced NALSA, nor have they embraced Naftage. So it is the community whose tools they have become. But for the government or for the authorities, it's an irritant. It's like a stumbling block. It's an impediment. So when we are going to the police station with these judgments, and we are telling the police officers, not all police officers, but so many of them would actually say that हमारे पास तो कोई order नहीं आया है, ऊपर से कोई order नहीं आया है, आप ऐसे judgment ऐसे बहुत judgment आ जाते हैं. So there is actually a deliberate refusal to recognize when the person is in front of you and the person is a trans masculine person, you can see that person is a trans masculine person, you will still choose to address the person by the dead name. And you will still choose to characterize the relationship as a same-sex relationship. So it is at this kind of basic level that we are talking about the disjuncture between the criminal justice system and the transgender persons and their identity and their dignity. So prison is like the last, it literally is the last outpost. I mean, when Justice Lokur talked about the whole of a super senior asking a straw and a sipper, I mean, it is exactly, we are doing that in the police station at the first instance of criminal justice system, and not at the last outpost of the criminal justice system, which is the prison and the jails. So it is this context of the complete denial, dehumanization of trans identity that we are dealing with. So when we have, there have been cases where the High Court's very, very, fantastically, they have recorded the self-identified name and gender of the petitioners. They have given the order of police protection. They have given, we have used habeas corpus jurisdiction extensively to get people out of arbitrary detention that their families have imposed on them. And High Courts have come to the aid. High Court have actually embraced NALSA. It is the High Courts, and it is the, basically it's the High Courts that have gone ahead with NALSA and Naftage and followed the spirit of the law. But the minute we take the orders to the police station, of course, it's a High Court order, they have to accept it, but they would still be addressing the clients, the petitioners in their dead name and the gender assigned at birth. So, how do you the law has done its job. Law has given you the relief. You have got a police protection order, or you have been released by the High Court from arbitrary detention. But this kind of prejudice, the stigma, the denial, the refusal, this requires a complete overhauling. When we are talking about training and awareness raising and sensitization of prison officials, and some of the recommendations of CHRI report have been fantastic. That is something that will happen if the first line of law enforcement officials are aware, sensitive, and sensitized. And most of the time, as lawyers, our feeling is that if you just follow the law, our job will be done and people's lives will be better. Yes. It's just that basic, that you just follow the law, follow what the NALSA is saying, follow what Naftage is saying, and follow and protect the constitutional rights of transgender people. And most of the problems can be solved. Yeah. Of course, there are many, many substantive and foundational issues that we are dealing with. But still, so in the context of prisons, my very limited contribution is that, as Bittu said and Sai said, now we do have a law on transgender protection rights. Yes, that law has been challenged. Several provisions of that law have been challenged because it diluted the self-identification rights that NALSA had given, the Supreme Court had given. So, but at the same time, it does provide a framework of non-discrimination, and there is a specific mention of custodial settings and custodial institutions. So, if you read the CHRI report and the legal framework that the CHRI report lays down, which is basically that reading the constitutional rights, the NALSA and the International Human Rights Law, there is already, and now with the new Transgender Rights Act, there is a broad legal framework that exists that can be used to protect the rights of transgender persons in prisons. But for that, the intent has to be there. For that, the understanding who is a transgender person. A transgender person is not just somebody who you think, who in your understanding is like a Hijra person. A transgender person is also Bittu. A transgender person is also Rachna. A transgender person is non-binary, as Bittu said. So these are if you do not have if the authorities, which they don't, in my 12 years experience of working on queer rights, most of the police officers, most of the government authorities, there have been cases where I have been in government meetings where the government authority person is meeting a trans masculine person for the first time. And these meetings have happened in 2018, in 2017. So in 2018 or 2017, you are meeting a trans-masculine person for the first time, then no matter how many declarations we have in NALSA or in Naftage, the reality, the dehumanization, the impact of criminalization, that continues to operate. And this is not an abstract thing that we are talking about. As Bittu said, that Rachna said, as my experiences go, it is like daily interaction. It's like every day I am being dehumanized. Every day I am living in the fear that because my documents are not right, or because I am visibly trans, or because I will be in gender segregated spaces, my identity will be questioned, I will be under suspicion, and as Bittu and Ratna said, I may get arrested just for my identity. So this is the context that we are talking about. This is the legal framework exists, and we can do in the sense of prison context also. The prison rules have to be modified, as CHRI said. Just one last point I want to make in terms of, we have now a new Mental Health Care Act, and Mental Health Care Act has very extensive provisions on how to deal with prisoners with mental illness in terms of their medical care, in terms of non-discrimination, in terms of transportation, in terms of if they fall sick, then what kind of medical care it is required. Similarly, HIV/AIDS Act. So even before the HIV/AIDS Act came into place in 2017, jails have had long history of dealing with prisoners with HIV/AIDS and requiring antiretroviral treatment, and then prison hospitals then have been modified to provide ART. So similarly, the prison hospitals in all the jails, wherever prison hospitals are there, they have to be equipped to provide access to gender affirmative services, which includes counseling, hormonal therapy, surgery if people need, or any kind of medical intervention towards gender affirmation. Now, that is now a part of not just the constitutional framework of fundamental rights in NALSA, as well as now it's part of the transgender persons' rights. So now it's a legal right as a transgender prisoner for me when I'm in prison. If I need gender affirmative care, I should be able to get that in prison hospital. So that is my one big recommendation. Thank you for listening. Thank you.
Thank you so much, Amrita, for those points that you've put across. Listening to you, Rachna and Bittu speak, a quote from the NALSA judgment itself, which talks about social justice does not mean equality before law in papers, but to translate the spirit of the Constitution enshrined in the preamble, the fundamental rights, and the DPSP, Directive Principles of State Policies, into action. With this note, I would like to invite now Ms. Jena Kothari, who is a senior advocate and the executive director at Center for Law, Policy and Research, to put across their points. Over to you, Jena. Thank you.
Thank you, Sai. And thank you to CHRI for inviting me to this wonderful panel. I would first like to congratulate CHRI for this brilliant report. I think it was long overdue, and I'm glad that CHRI has taken the initiative to work on it and to bring this out. Thank you also for inviting me to this really esteemed panel. It's a great honor to be part of all the eminent speakers here, so it is really my privilege. I've gone through the report and just wanted to give a few responses to some of the issues that really resonated with me. One is certainly, the report highlights many important issues that face transgender persons within the criminal justice framework and within prisons. And some of these issues I would just like to highlight because these really stand out. One is, of course, the specific vulnerability that trans prisoners face in prisons, the violence faced by inmates, especially trans and intersex persons. And the violence is not just physical or mental harassment, it's sexual abuse, which I think trans persons are particularly vulnerable to, Then the biggest issue, of course, is gender identity-based placement. NALSA talks about self-determination of gender identity, but how is that practiced in prisons? It isn't. What happens in prison settings, and I'm saying, of course, your report documents it, but this is also from personal experience as I have represented trans persons, getting bail, and in many other criminal cases. The biggest difficulty is that placing is not done based on self-determined gender identity, which is their constitutional right. Placing is done on the basis of what their name is, on what whether they've undergone gender reassignment or not. And that is a really huge issue, because that determines the violence faced by them. If a person whose gender is, self-determined gender is not reflected in their bodily checkup or their name, they are placed in the wrong cell, the gender which they don't identify with, and most commonly it is trans persons being placed in the male prisons, and they are in fact therefore exposed to a further and intense form of harassment and sexual violence. The next issue, of course, is access to medical care and healthcare. We've had issues where trans prisoners were in jails, they were undergoing hormonal therapy, they were in the process of undergoing reassignment. I think it's important for prison authorities and courts to understand what all of these treatments are like, because these are not one-off treatment that finishes in one day. These treatments go on for several long periods of time. There was a case where a trans person was undergoing gender reassignment and a surgical procedure, and she needed her hormonal medications. She needed she had a complication with a top surgery that she had, and she couldn't get access to any treatment within the prison setting, because even to get expert plastic surgeons in regular hospitals for trans persons is itself not accessible everywhere. So certainly in prison settings, if a trans person is having a particular complication with her top surgery, you're not going to be able to get it in prisons, and the prison authorities and courts were not willing to get her out to give her medical treatment. So that is of particular concern. The issues of privacy and dignity, being placed in wrong gender cells, having access to washrooms, and all of that becomes a really big issue. And then, of course, the larger issue of safety in prisons. Trans persons are at risk of facing violence not only from prison inmates, but also from prison authorities. And I know we have prison authorities here, but I think we need to be aware of what happens in prisons. There are many judgments that have gone to court, and courts have also, recognized it. So we need to address it together. So I think, and another issue which I feel we need to put some emphasis on, I know your report has all of these issues that you've addressed, but we see these things get heightened when trans persons apply for bail, and bail is often not granted because of the stigma that trans persons face, and not getting bail increases their vulnerability in prisons to all of these issues. And one of the reasons why bail is also not granted easily is because judges and magistrates are also not sensitized to trans issues. So, it's not just an issue of prison reform, but it's also an issue of ensuring that judges and lawyers are, prosecutors are more sensitized to these issues. I think some of the other speakers have spoken about prison entry records, FIRs, ensuring that their chosen gender identity is, recorded. Right now, what happens is that it just happens based on your Aadhaar card and whatever your documentation is there. But the biggest challenge for trans persons is getting their documentation to reflect what they want to reflect. We have had to go to court for every single name change to be documented. And these are usually done by trans persons who are aware, who have access to lawyers. CLPR, at CLPR, which I head, we run a legal aid cell called the Trans Law Cell, where we provide legal assistance to trans persons. But how many trans persons can find their way to CLPR, and how many can we represent? But even then, we have at any given point of time at least 5 to 10 cases for name change in the High Court. in Karnataka. So we can just imagine the large number of trans persons who don't have their documentation done. And that determines how they are placed in prisons, and that determines the violence that they face in prisons. So that's a big issue. I think some of you spoke about the Telangana Eunuchs Act, and how do we ensure that this criminal identity of trans persons is removed and changed. Section 377 was decriminalized in the Navtej case, but that doesn't mean that the criminalization and the criminal identity and stigma that trans persons face is removed, because 377 is still there, right? 377 is still there and is still a way of, a form of threat for non-consensual conduct. And it is used in many instances to threaten trans persons. So we still have a lot of work to do, but I think that prison reforms is certainly a way to start. I know that Justice Lokur spoke about lawyers being more aware and sensitized. I think that is extremely important. I think every part of the criminal justice system has to, be engaged on this issue. Prison authorities, courts, judges, prosecutors, police, and lawyers. We all play a part. And, I think we all play a part to ensure that the rights of trans persons are protected, like the rights of every citizen is protected. Yes. And that, I think, is what should be the need of the day. So I'll end there. Thank you, Sai, and I look forward to being part of your work on this in the future. Thanks.
Thank you so much, Jenna, for putting across those points so eloquently, I must add. Just a few pointers that I would also like to speak about with the overview that has been presented by Professor Bittu, Rachna, Amrita, and Jenna. It is also necessary to note that given the pandemic and the COVID-19 situation, specifically in prisons, the situation is surely more grim in the present time than it was before, and it requires special attention on behalf of all stakeholders to make sure that the transgender persons who are in prisons right now are given proper care and are given proper recognition in that record. Going forward, I would request that as far as possible, references to what the previous speakers have said can be minimized to make sure that we make the most of the time that we have. And having said that, I would now request our next speaker, who is Dr. Ahmed, who is a former director at the Academy for Police and Correctional Training. Dr. Ahmed, we cannot see you yet. Could you also unmute yourself, sir?
Okay.
Thank you so much. Over to you.
Yeah. Good evening to everyone. And I've been going through the concerns expressed by each one of the speakers. And I'm glad, being a prison officer, I had been at the helm of affairs for more than 37 years, having studied prison system all over the world. And some of the suggestions made by the speakers were really worthy of consideration. But from the prison officer's point of view, I would like to say certain things which are very, very relevant to understand the problems. The number of transgender prisoners is very, very small. At the end of the year 2019, there were 478,600 prisoners confined in our prisons. Out of that, only about 214 prisoners do belong to transgender category. Now, none of the prison manuals have provisions relating to the management of transgender prisoners, except perhaps Delhi prisons. Even the Model Prison Manual 2016, to which I was also part of, this was drafted by Minister of Home Affairs, has any rules about dealing with transgender prisoners. And then the United Nations Standard Minimum Rules, which is also known as Mandela Rules, which is a document which is obligatory to all the prison, obligatory on the part of all the states to implement the rules regarding the treatment of prisoners, minimum standard, United Nations Standard Minimum Rules for treatment of prisoners. Even that doesn't have specific provisions relating to transgender prisoners, except saying that every person admitted to jail should be treated equally, and that no discrimination on the basis of race, religion, sex, language, etc., etc. But then, let's see the National, Crime Records Bureau, which takes out the prison statistics. They have no third category at all. They only discuss about male-female prisoners confined in Indian prisons. And the judgment, Nalsa judgment, the prison officers are not aware. Unfortunately, none of them have said that they are aware of Supreme Court decision. Even the prison headquarters in almost all the states have not issued any kind of rules regarding the management and treatment of transgender prisoners. And Model Training Manual, which has come out in 2007, of which I was a consultant, we have made provision for training of transgender prisoners, gender sensitization program, in which we have said that transgender prisoners should be part of the training program. In that, we have mentioned transgenders as a group under unspecified special category prisoners, and along with the prisoners with mental health care needs, prisoners with disabilities, life and long-term prisoners, and prisoners with terminal illness, older prisoners, and foreign national prisoners. Of course, the specified special category of prisoners include women prisoners, adolescent and young offenders, remand prisoners, high security prisoners, and prisoners sentenced to death. But however, in spite of including in the Model Training Manual, I'm not aware of any training institute taking up the training aspect of in relating to transgender prisoners, though we have gender sensitization training programs where women are discussed mostly. Prison staff hardly receive any training other than women prisoners. However, general human rights principles are taught everywhere, like non-discrimination on the basis of sex, religion, language, color, etc. The prejudices that prevail in the general society about transgender prisoners also prevail among the prisoners, unfortunately. Prisoners do not treat these transgender prisoners in the same manner as they treat other prisoners. It is a hard reality. The transgender prisoners are subjected to medical tests for determining their sex in a very degrading manner. It is a fact. But you should also remember the prisoners, every prisoner is admitted on the basis of a warrant, whether it's a remand prisoner or a convicted prisoner convicted prisoner. And the jail rules provide for, as soon as a prisoner is admitted, first his warrant is checked and his identity is checked. Then in case all prisoners are screened in case they are carrying any prohibited items or contraband items. And this searching is invariably done for each and every prisoner. And there are rules as to how to search these prisoners. In the case of women prisoners, they invariably have to be searched by the women staff members. In the case of men, by the male staff members. But in the case of transgenders, unfortunately, since we don't have any category as such, and the warrant also doesn't specify that he's a third gender in most cases, third gender, so the jail staff implement the normal rules. Now, the National Human Rights Commission sometime back had had given specific instructions, which has become a rule now, that every prisoner who is admitted to prison should be medically screened within 24 hours. Now, there is a pro forma for that. So the medical screening is a must. So the prison authorities have no option in that. So all prisoners who are admitted are produced before the medical officer, and the medical officer then examines, and then we will bring to the notice of the superintendent of anything which he thinks should be brought to the notice of the superintendent. It is a fact that till recent times, even now in some prisons still continue, when the doctor finds that the person who has come has a different type of genitalia, then he will bring it to the notice, and he will then says that this person should be classified or categorized as a male or female. I'm talking about the things when there are only two categories of persons who are admitted in prisons as per the rules that say that male or female. Now, basing on that, in case the magistrate's warrant is silent about these aspects, then the prison authorities bring to the notice of the magistrate, and the magistrate changes again. And in case it is a male to female prisoner, he sends them to male prison. In case it's a female to male prisoner, he is sent to female prison. This is happening now, but in some states they have started now classifying this transgender prisoners as transgender or other category. Now, some magistrates in some states have also started putting as other transgender prisoner. Now, this is one aspect of it. The other aspect of it is now, since the number of such prisoners who are admitted in the prisons is very, very small, there is always a problem for prison authorities. Now, prisons do not have separate accommodation for such type of people. So they have, however, certain cells which are normally meant for people who create security problems, or who require to be kept under observation, or who require to be kept under protective custody. So since the prison officers have no other alternative, because instances were reported earlier when transgender prisoners were allowed to move freely in certain areas of prisons, they were either exploited by other prisoners, or some certain incidents happened which did not go well with the prison authorities. So the prison authorities thought from the overall security point of view, or from the order point of view, they felt that keeping these prisoners in the cells is the most and the safest option. I know, keeping people in the cells creates its own problems. In fact, it restricts freedom of the prisoner confined, and he cannot go around as he likes or talk to prisoners and move around. So, but it can't be helped, as prison officers say. It is only Kerala. They have established or earmarked a separate enclosure for such prisoners, transgender prisoners. But again, there is a problem. They are either supervised by the male prisoners, or in case female prisoners are female staff, male staff, or female staff. And but in the circumstances, what Kerala has done is being copied by other states as well. I have discussed this issue with many prison officers, senior prison officers, as to how to what should be the future. As far as these prisoners are concerned, and many prison officers feel that since the number is very less and hardly they come, one or two people come once, in a year, and these prisoners should be considered as a special category prisoners, or come under the category of vulnerable prisoners. Yeah, that is the right approach. And basing on this, their classification as vulnerable or special categorized, and special protection has to be given to them, or special care has to be taken to them. And the medical officer of the jail also should take special care of them about their problems. And then now apart from that, as rightly pointed out by Justice Madan B Lokur, that fundamental aspect is that, first of all, the prison officers are not sensitized. In fact, instances are even now it is happening that prison staff, especially at the lower level, they make fun of these people and literally harass them. There was some incident where such transgender prisoners were also assaulted for some purpose. But in any case, what is lacking is sensitization. I mean, sensitization. On the part to all the staff, prison staff, officers, and the lower staff. Everyone should be sensitized. Training programs should be organized for them. And as rightly pointed out by CHRI in their report, all the recommendations they made are very, very valid, and they should be implemented. Mostly, as far as prison is concerned, I feel that the prison academies should be immediately be able to implement these sensitizing programs immediately. And then the prison inspection procedures, for example, the prison visiting system, which consists of district magistrate, district superintendent of police, and district collector, and so many other education officers, etc., official as well as non-official officers, they must be requested whenever they visit the jail. They must specifically meet these people and find out about their problems. And that also goes a long way in perhaps helping the transgender prisoners improve their condition in prisons. And I also feel that the prison officers inspection, the senior officers who inspect the prison should also make it a point to go and meet these people and find out their problems. And that is very much necessary. Yes, sir. So as far as the other things are concerned, like, Justice has spoken about it, and also CHR also has spoken about it. The government of India should take up a policy decision and issue a policy document as to how these transgender prisoners should be treated. And then the next is that BPRD also should send circular to all the state governments about this. And all training manuals should be updated so that proper training programs are included in that. And then the prison department should also develop some awareness programs because other prisoners also do not have an idea. They also should be sensitized by way of bringing awareness programs. Yes. And as I told, they should be included in one level. My best, I think the best recommendation would be, I have found, because I have done a bit of work on that, the prisoners, the prison should be resorted, should be resorted as a last resort. But in our country, what we see in our prison setup is that people who are not threat to the society, who are not threat to society at all, to the peace and security of the society at all, and involved in non-serious offences are being brought to jail in large numbers. And absolutely, there is no reason for bringing such people to the jail at all. In fact, we should learn from other countries like Scandinavian countries where the jails are getting emptied because they have realized that.
Dr. Ahmed, we are not able to hear you. Also, so we are running a little over time. So if you could...
Okay, that's my last recommendation. My recommendation, last recommendation would be to think about alternatives to imprisonment, where people who don't deserve to be in the jail are people who are involved in non-serious offences. They should not be brought to jail at all. That will be a great reform if it is implemented as early as possible. And I thank CHRI for giving me this opportunity. I congratulate them for this wonderful subject. Thank you.
Thank you so much, Dr. Ahmed, for putting across your points in this. I'll quickly go on to the next speaker, but before that, I have a quick announcement to make to everybody who's tuning in to listen to this. We understand that the program is running a little ahead of, little over the schedule, and we might be delayed in finishing the program for about 30 minutes. We request your continued patience for the same. I would now request Mr. Bimbadat Pradhanji, who is the Secretary General of National Human Rights Commission, to put across their points on this issue. Over to you, sir. Thank you.
Thank you, Shai. Good evening, respected participants. I am new to this whole ecosystem, and again we are running over time. I will be very, very precise. And I am thankful to CHRI for giving me this opportunity. And all of us are aware, I am not going to repeat whatever has been, deliberated. We know that transgender community is one of the most vulnerable and marginalized sections of our society. And when they are inside the prisons, whether it is 200 odd numbers, I am not going to question the number, but having worked as a collector in a district where the capacity is 400, but there are 4,000 people inside the prisons, whether it is restroom, whether it is kitchen, whether it is basic amenities for a human being, less said the better. Now coming back to the transgender as a community, the gender identification, the housing decisions within the prison, the access issues to healthcare, the violence and the sexual assault, all these are the issues. I am not going into those kind of challenges or the concerns, but what is the role of the NHRC? Whatever has been stated, NHRC is committed. It will go to complement and supplement the efforts of the prison administration, whether it is guidelines to protect the rights of the transgender persons in the prisons, or it is the transgender person as a vulnerable category of prisoners, or the necessary guidelines and advisories on the rights of the transgender persons in the prison. We will do necessary consultation and issue those guidelines. This much commitment, this much assurance at this point of time I can give. Now, if you take the community in totality, the 2009 Delhi High Court's decision, which is known as the Naz Foundation and Government of NCT of Delhi, then you take that 2013 where the Supreme Court overturned the Delhi High Court's decision and said it is legally unsustainable. Now, when you go back August 2017 decision, the right to privacy is a fundamental right. And the Honorable Supreme Court also observed that right to privacy and protection of sexual orientation lie at the core of fundamental rights, which is guaranteed by Articles 14, 15, and 21 of the Constitution. And when we look back, the decision on September 2018, the Honorable Apex Court decriminalized homosexuality by declaring Section 377 of IPC unconstitutional. The Apex Court also ruled that individual autonomy, intimacy, and identity are protected fundamental rights. This is the journey of the Delhi High Court and the Honorable Supreme Court in the domain of sexuality of LGBT community. Now, if you go back a little bit, the narrative has been, but the issues relating to right to education, right to livelihoods, right against discrimination, still these are the challenges and the issues for the society as a whole. And when I look back 2014, NALSA versus Union of India, that has been discussed earlier, I will be very, very precise. Honorable Apex Court declared that transgender people are socially and economically backward community. Therefore, entitled for reservations in education and jobs. directed the government of India and the state governments to frame welfare schemes for these very vulnerable groups. And if you take the 2013 Honorable Madras High Court's decision, gave permission to a transgender as a female candidate to write the Tamil Nadu Public Service Group 2 examination. These are milestones. Why I am narrating this? These are definitely progressive milestones in our journey to claim the rights of the transgender community. Recently, if you take the Kolhapur district Lok Adalat, 2 transgender persons have been appointed as panel members in Lok Adalat of Kolhapur district of Maharashtra. And to take it forward, I can assure we are also thinking in our core group, we have decided we must give adequate representation within the Nhrc for the transgender community. Now, to conclude, the judiciary has played its role. Now, it is the society, it is the institutions, what Justice Lokur was pointing out, whether it is the Lal Bahadur Shastri Academy Administration or the National Police Academy or the state governments or the Ministry of Social Justice, now we have a role to play. Therefore, if you take the Transgender Persons Act 2019, it is a landmark act towards the rights of the transgender community. Every transgender shall have right to reside and be included in his or her household. This is a huge, huge progressive step. 2, no government nor the private organization can discriminate against a transgender in terms of employment, in terms of recruitment, in terms of promotion. It's a huge step in our journey towards the rights of the transgender community. 3, there is a provision for grievance redressal. The National Council for Transgender Persons, the NCT, in the Ministry of Social Justice, will advise the central government and monitor the policies with respect to transgender persons. And there is a penal provision. There is a penal provision if somebody is removed from his or her house, if there is emotional harassment, if there is sexual harassment, there is also penal provision in the Transgender Persons Act 2019. And to conclude, the issues such as same-sex marriage, the property and the civil rights are yet to receive legal recognition. So we have a long way to go. And whatever has been deliberated, whether it is necessary awareness, necessary sensitization, we have still a long way to go. And to conclude, I am a strong believer, if I have to quote the Malala Yousafzai, the Child Nobel Laureate, I will repeat, one book, one pen, one child, one teacher can change this world. And all the dignitaries who are participating in this virtual workshop, I have faith and I am confident each one of us can contribute to protect and to promote the rights of this very vulnerable community. And we must get up, we must stand up to fight for the rights. Thank you.
Thank you so much, sir, for those inspirational words, and also for giving a call for action among all the people who are participating in our event today to be more responsive to transgender persons and their needs and rights, specifically in the context of prison. Going forward, the last but not the least member of our panel is Justice S. Muralidhar, who is a judge in the Punjab and Haryana High Court. Sir, I would request you to kindly put across your points. And soon after that, we will have questions and an open discussion. We request people to start posting their questions on the chat so that we can take them up sequentially. Over to you, Justice Muralidhar. Thank you so much for participating.
Thank you, Sai. I know you've asked us not to repeat what a previous speaker has said, but only one thing I wish to repeat is it's such an honor to be part of this panel and an amazing experience to listen to all the panel speakers thus far. I know we are really at the end of the session and we're running out of time. So I'll straight away get down to some of the issues I think we need to address. One thing that is coming clear from the presentations that we've had so far, and I think even this workshop is possible only because of the NALSA judgment. It was an important trigger. The NALSA judgment was a trigger. I would like to disagree with some of the speakers that the judiciary has done its job. I don't think this is a task that could be taken up and completed in any time frame. I think it's a work in progress. I know from my personal experience of being part of the NAS Foundation judgment that what NAS did was to really, visibilize an issue, knowing fully well that that will generate a dialogue. But even as we delivered NAS, we understood the complexities of class and caste, which is a big issue in our country. And I was very, something resonated when I heard both Bittu and Rachna, that they are not a homogeneous, transgenders are not a homogeneous category at all. And when we talk of transgenders interacting with the criminal justice system, I think we need to be very consciously aware, conscious of the complexity of the issue of caste, class, and all other intersections when it comes to transgenders. Am I audible? Am I audible?
Yes, yes.
All right.
Yes, sir, you are.
Second issue I wish to highlight is, therefore, we need to go back with PILs to the various high courts and the Supreme Court. Maybe we can revive NALSA's, the NALSA proceedings to highlight some of these individual issues that still remain to be addressed. And what Justice Lokur said about implementation, I think that needs to be taken back to the Supreme Court. Because when we're looking at implementation of various facets of the NALSA judgment throughout the country, having the Supreme Court at the center of it would be really useful. Then you can get the responses of the various states, just like it happened with the DK Basu judgment. Even today, you have the DK Basu case still pending in the Supreme Court, and for good reason, because for various facets of implementation of the DK Basu guidelines, you have to constantly keep getting the responses of the states, trying to understand what issues they face. And from the presentations of Mr. Ahmed and Mr. Pradhan, it becomes clear that you have to have a multi-party dialogue. And that dialogue can be facilitated by these court proceedings, which can bring about the complexities involved in implementation. So I would, as a second point, ask for revival and initiation stemming from NALSA of further proceedings that focus on specific issues of implementation. Third, I think we need to position this not just as an issue of transgenders in prisons. I think we have to look at the broader issue of transgenders in the legal system as one part, and within that, transgenders in the criminal justice system. Because from the presentations we've heard so far, we can see that the genesis of the problem is much earlier than transgender landing in a prison. So that training, the sensitization we're talking about, has to start at a much earlier stage. So the third issue is to not position this issue as just as an issue of transgenders in prisons, because then we're talking of numbers, then we tend to think that 214 is a very small number compared to the 4.5+ lakh population in prisons. But if we really need to understand the complexity of the issue in all its dimensions, I think we should look at it as transgenders in the criminal justice system as a whole. Fourth, when we talk of just the criminal justice system, we need not focus, and we should not, I think, focus just on prisons, but all penal custodial institutions. We're looking at observation homes, Nari Niketans, and maybe other custodial institutions, including mental health institutions, which are all within the penal custodial format. So we need to expand the scope. And fourth, the role of the judiciary, which I'm coming to very specifically. I completely agree that there has to be training and sensitization of all levels of judiciary. And we're not talking just of, the subordinate judiciary, but even the High Court judges, and maybe even get Supreme Court judges to come and participate in these kind of workshops. I think we should start admitting that there are many facets of this complexity of this issue which we are not aware of. Today was an eye-opener listening to Bittu and Rachna for me, personally. And Bittu put it very beautifully when she tried to tell you why it is so humiliating to be strip searched. And I would urge Mr. Pradhan in the Nhrc to pick up this one issue. We can do it step by step, as Justice Ruth Bader Ginsburg would always urge us to do. Take one reform step by step. If you just picked up this issue of strip searching in prisons, and it could be an issue of privacy and humiliation, not just for the transgender persons, it could be for any prisoner. So why don't we pick up this issue? And if it's an archaic practice, if there's another less intrusive, far better way of doing this, why don't we do this? So I think we can pick up some of these issues that have emerged even during this dialogue that we've had in the last 2 hours. And there's much to be done. Fifth, I would think that the judicial academies in the various states, the state judicial academies, could be excellent places for fostering this dialogue. And dialogue just not between transgender persons who should be heard, their voices should be heard in these kind of workshops and awareness seminars. Apart from them, we should have prison authorities, just like we are having today. Prison authorities, the police authorities, the advocates, the judges, all sit around to listen to transgender persons. I completely agree with what Sai said in the first instance, that this dialogue has to be led by the transgender persons. And if we do that, I think we can get on the on paper policy changes, even statutory changes that can then be pushed forward for implementation. And we should let the transgender community take ownership of this. What invariably happens, it becomes a top-down approach. And we can see the distinction between the Nalsa judgment and the act that has come about. And it's a very, very serious difference in the process of self-identification. And that came through very well, both in your report and in the presentations today. So I would urge that this report itself becomes the trigger for going back to the courts to say, please continue from where you left off. I do not think the judiciary has completed its task. The judiciary is definitely part of all of these efforts to push forward the move to recognize and respect the rights of the transgender community. Thank you very much for giving me this opportunity. And I hope to have more such discussions. As a chairperson of the Punjab State Legal Services Authority, I can tell you that I'm going to slate a discussion around this kind of a report, or maybe this report itself, at the level of the state here, and get all the other players around the table to listen to all of you. Thank you.
Thank you so much for those powerful words, Justice Muralidhar, and also for the call to action that you have given to various stakeholders, specifically in the judiciary. That concludes our session for today, the panel specifically. I would like to request any of the participants who have questions to kindly use the raise hand feature that is denoted with a hand sign on your screen. As we receive them, I will moderate the questions and sequentially ask the same. kindly provide me a few seconds to take out any technical discrepancies. I can see Mr. Varun Sharma raising their hand. I would request that you could unmute yourself and speak and put across your question as briefly as possible.
Thank you, madam, very much for giving me an opportunity to express my opinion. As a correctional officer and also a district probation officer at Patiala, I will like to make a very small suggestion regarding these transgender persons. So in case of petty offences committed by transgender persons, the Honorable Court should mandatorily direct the concerned probation officers to prepare a pre-sentence report of the offenders, and after considering the mitigating circumstances, the Honorable Courts can consider the transgender persons to release them on probation of good conduct under the supervision of probation officers. This can go a long way to prevent the further stigmatization and thereby also provide an opportunity for the transgender persons to rehabilitate instead of being incarcerated and prolonging their agony. Thank you very much, madam.
If any of the panelists want to respond or have a comment regarding the same, please do. All right. We have Mukesh Kumar Sharma ji. If you could kindly unmute yourself and ask your question or comment as briefly as possible, it will be great.
Yeah, thank you, ma'am. This is Mukesh Sharma from Punjab Jail Training School, Patiala. As our retired DIG and Director of EPCA, Dr. Ahmed sir has rightly said, we need to organize the training sessions and we need to have interactions with the prison officials as well as with the inmates to sensitize them towards this issue. And at the same time, when we incarcerate the transgender person in the same facility, there are some issues. So as rightly said by Justice Muralidhar, there are n number of institutions like Nari Niketans, the mental health care centers. So we need to devise a mechanism so that a separate institution may be created for transgender person. So that feasibility may be worked out in the criminal justice system. Thank you so much.
Good evening, ma'am. This is Mithilesh, IG Prisons Bihar.
Please go ahead and ask your question, Mithilesh. Thank you.
This question as well as one suggestion regarding any progressive thought in the prison administration. As we have know, there is no provision in the prison manuals regarding transgenders. Maybe some more issues may be there for which CHRI is working or any university is working or any study group is working. My humble request will be that if we are taking any special study or any case report or any the progressive work, it is better to engage all the officers beforehand. Like today I would like to share with you all 59 prison officers from Bihar has joined this workshop or this webinar just to get sensitized how this issue is there. Because last year we get a case where we got perplexed how to go ahead with this detainee. But anyhow, since case was for the very short period, so problem was not arised. My humble suggestion is that this request is to CHRI also, because they are very pioneer for prison reforms. They are collecting data before sending their data as a RTI or to every individual jail. So if we can do a pre-seminar about the issue, definitely that issue will sensitize the jail higher officials as well as jail officials. So data collection will be very fast as well as purpose will be very clear. So I think more data, more analysis and more positive things will be there. And second suggestion will be that after some time, we should also reflect and we should also check the progress on the issue. Suppose this report is compiled on the report of the 9 states. If suppose after 6 months we again do a seminar on the same issue, definitely the data progress will be more, sensitization will be more, as well as the progress will be there. Several states will include the provisions. Thank you, sir. Thank you very much.
Thank you so much, Mithilesh ji, also for we have initially during the launch of the report also given a call for collaboration. We would love to take this forward with individual prison departments across the country to have more conversations, to create more sensitization, and to take conversations forward with keeping this community at the center. I would like to read out a comment by our International Director, Sanjay Hazarika, who states, would like to hear Mr. Pradhan's response to Justice Muralidhar urging review of strip searching during admission of prisoners.
Can I take half a second? Yeah. So what Justice Muralidharan has given this will go, with a sequential approach. But this much assurance I can give to this August House, whatever is expected from the NHRC, it will be done, it will be done, it will be done at the earliest. And to my younger colleague from Bihar, Mithilesh, I think this is the opportunity. You can use the NHRC as long as I am there, whatever SOP, guidelines or advisories you want to create for your prison officials. We are there 24/7. You please utilize the good offices of the NHRC. It is there 24/7 to help you because you are there. And I will go out of the way because I belong to Bihar cadre. So this much I think, you must use the office of NHRC to sensitize the officials of the Bihar prison administration. Thank you, sir.
Thank you, sir. Thank you very much, sir, for your kind support and blessings, sir. Thank you, sir.
Thank you, everyone. Now, we would go on to one question that has been asked by Shruti Srinivasan. They ask, in the event that the inmates have been sexually assaulted by prison officials, they are often forced to stay in the space as the perpetrators, further increasing their chances of re-victimization. How can this be addressed? If anybody on the panel would like to take up this question, kindly do.
Yeah, I would like to answer.
Yes. Yeah, please.
I mean, such. Yeah.
Dr. Ahmed and then Justice Muralidhar. Okay, go ahead.
Okay. Any activity, such kind of sexual assault on prisoners is taken very, very seriously, and immediately he will be suspended and a case will be booked against him in the police. So the man has to face the criminal prosecution. So it is taken a very, very serious issue in the jail administration.
Yeah, my own feedback about complaints by inmates is that they're very reluctant to give complaints because the gap between the giving of the complaint and the action taken on the complaint is such that, they can get victimized not just by the perpetrators, but they fear even victimization of the jail administration. So I would ask that, the visitor to the jail, which is the district judge, he should be sensitized to have a one-to-one interaction with such a person who has been a victim of assault by assuring some kind of action that would be taken. You see, unless we give some assurance to the complainant, complainants will not come forward, particularly in a jail atmosphere. In fact, this is also the reason why these video remands that we talk about is not always a healthy practice, because staying in the prison, appearing before a camera and talking to the judge is very different than being in the courtroom and talking to the judge. I think this will require a combination of the jail visitor, which could be the district judge or somebody delegated by him. It could be also the legal services authority, the local legal services authority panel lawyer who visits the jail. I think the prisoners should be given the confidence that they can take into confidence such persons the jail visiting lawyer and the jail visiting judge to disclose to them that this is the problem they're facing. And it should be the duty of these, the judicial officer and the jail visiting lawyer to take the matter forward to make sure that the victim is not further victimized.
Thank you so much, Justice Muralidhar. One final question that we have, and this question has been
I will just supplement what Justice Muralidhar has said and Dr. Ahmed has said. See, I think, if we have to give just one liner, whether it is sexual assault or the sexual harassment or the domestic violence, the law must be made transgender inclusive. That is the next step. All of us, we must strive for that. The law for the sexual assault, the law for the sexual harassment or domestic violence must be transgender inclusive. That is the next step we must strive for. Thank you.
Thank you so much, sir. The final question that we'll be taking for the session is an open question and also specifically to Professor Bittu, asked by one of the lead author of the report as well, Mr. Arijit Ghosh. So regarding the perspectives that have internationally cropped up on drastically restructuring or changing the way in which prisons are organized or prisons are instituted in the country or otherwise referred to as abolitionism, what would the perspectives of that stand in the Indian context? Bittu, if you could speak a little bit about that, that would be great. Hello, hi. I can't hear Bittu yet. I think they might be unavailable.
No,
all right, then I'm right here. Okay, yeah. Hi. Okay, Bittu's here. Quickly, if you would answer that, that would be great.
Could you just repeat the question for me?
The question was that regarding the international perspectives that are coming across on drastically restructuring or changing the way in which prisons are imagined or envisaged, or otherwise also known as abolitionism of prisons, how would you fit that into the Indian context, and what would perspectives specifically with regard to decarceration of trans people be in this accord?
Right. This is a very good question. I mean, in general, I think all of us I think many of you absolutely correctly put your finger on the question of how it is that very often jail is the first step for anybody who is seen as transgressing any kind of social norms, rather than really being really sort of alternatives being considered. I think that so I'm also speaking as somebody who's a professor of psychology and biology, right? I know that there's a lot of work still being done on ways in which therapeutic
We seem to have lost Bittu again. All right. Given that there might be a few technical glitches on Professor Bittu's end, we would conclude the session here. I would like to take this opportunity to thank everybody who has attended this event and has also spoken on such an important issue. This entire project, the report, and this event has a special place in my own heart, being a trans person who's working on the issues of access to justice for LGBT communities and queer communities. And with that note, I would heartfeltly thank everybody who's participated. All the assurances that have been given on this platform are truly encouraging to see. And we hope that future collaborations and work to practically realize the rights of transgender persons is carried forward, and we will follow up with all of you individually. That is an assurance on behalf of CHRI that I can make. And thank you everybody for attending. Have a nice evening and have a nice weekend. Thank you.
Thank you.
Thank you. It was a wonderful program. Thank you.
Thank you.
Thank you.
Thank you.
Thank you, Sai. And thank you, everybody.
Thank you, Sanjay.